I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are featuring number 61 in our compilation series, and we will be in 3 different judges' courtrooms on today. Before I get into the judges, don't forget to like, share, subscribe, comment, all of those great things. Also, there will be no commentary at the end of these proceedings, and there will be chapters added just in case you want to jump around. Now, with that being said, the first judge's courtroom that we're going to be in on today will be that of Judge David Robinson out of the state of Michigan. Second, and this will be a sprinkles on top. If you are familiar with this channel, we do Sovereign Citizens Hall of Fame with sprinkles on top, meaning non-sovereign citizen cases. We will have one of those in the courtroom of Judge Lynise Bryant out of the state of Michigan. And if you know anything about her, she does not play around. And last but not least, we will be in the courtroom of Judge David Fleischer out of the state of Texas. Guys, as always, thank you for joining me for these compilation videos. And listen, it's about that time. Let's go ahead and jump into number 61.
We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right,
So
Mr. Hurst.
we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this. This is not a clown show.
Oh my goodness.
One at a time.
I can't finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickarts say what it is she wishes to say. then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhart, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she have to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Strickhart?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Should they have sent me something before they sent me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions. Same as her. All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Yeah.
if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side. All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the third page. The agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
All right, I'm ready on Shabazz. No, I'm sorry, Tripp. I'll do Tripp first, because did you tell me Tripp was ready earlier?
Yes, Your Honor.
I'm ready on Tripp. And what are we doing on Watson Wilson? Am I coming down for a trial?
We have a resolution, Your Honor, PTR. We're in receipt of what we want.
Okay, this is case number 244438701, the People versus Christopher. Might be Lorenzo is cut off on the docket. Tripp, defendant is charged with child abuse, 4th degree. Today is the date set for final pretrial conference appearances, please.
Morning, Your Honor. Alex Hill on behalf of the people.
Here, Mr. Tripp will continue, Dennis Stevenson on behalf of Christopher Tripp. Mr. Tripp, please say your first, middle, and last names.
Christopher Lorenzo Tripp.
All right, Ms. Stevenson, how are you proceeding? Because you was getting ready to tell us.
Right, Mr. Tripp is going to continue his plea of not guilty, but I would ask for sidebar with the court and the people.
Right now?
If I'm
This might help.
So that means you all want me to come downstairs because Mr. Hill is not on this thing?
I could
But he and
admit-
Ms. Coleman did come in here or something.
Okay.
Okay, thank you, Your Honor. We're gonna go into the room right now.
All right, come into the room.
Thank you, guys. Thank you for your patience.
Then I guess we need to go to breakout. Wouldn't it be funny if we just started talking right here? Join me in breakout room number 1.
You just have to see it.
All right, back on the record with the People versus Christopher Tripp.
No. Oh, I got
Man, I'm only gonna let you talk to him for about another minute.
Okay, Your Honor, thank you very much for that, Grace. Trying to just figure out how Mr. Tripp can help the people to have a conversation with the complaining witness's mother.
Oh, well, I'm gonna tell you how we're gonna have a conversation with him. If she don't answer the phone the next time, if she doesn't respond to that text the next time, I'm gonna send the police out there. I'm gonna send the police to the child's school. And then we're going to take care, custody, and control over the child. And then they'll have to get the child from protective services. So let me be clear. Let me be clear out of my mouth. Let me be clear. If Mr. Tripp resides with the mother, then he better go home and tell her that she better answer Mr. Hill's phone call. She better respond to his text, and she better produce my witness, because failure to do so is going to cause me to show cause her, and I'm going to have her arrested. Listen to me clearly and carefully. I'm going to have her arrested, and I'm talking about the mother of the child. Whoever has care, custody, and control over the child, they had better produce the child to Mr. Hill. They had better produce the child to Mr. Hill. Stop talking. Stop talking. Whoever has care, custody, and control of the minor witness had better produce the witness to Mr. Hill. Failure to do so is going to result in me contacting protective services, in me issuing an arrest warrant for interference with this criminal prosecution. It is going to result in charges for witness tampering. Listen to me carefully and clear. I'm not playing. Now, the case can be resolved, and I will entertain pretrial resolutions, which will include in-person classes. But what I will not do is allow some person to bully this court system. It's never going to happen. The bullying of this court system, it's never going to happen. So whoever has the child, I know the baby got a cell phone. It's 2025. But what I also know is that she's in school. She's in school. Either she being homeschooled, and that address has to be registered with the state, or she's in a physical school. And she's going to talk to Mr. Hill. The witness is going to talk to Mr. Hill. And if the mother has custody, they're going to produce the child. If Mr. Tripp has custody, he's going to produce the child. Whoever fails or refuses to produce the child, I'm going to have those charges issued against them. And we're going to have a warrant for their arrest. All right. Now, any further facilitation, that's y'all business. If Mr. Hill comes back here and tell me that they still not answering his calls, he can't find his witness, this minor witness, it's going to be somebody is going to have to deal with that, and they're going to have to deal with me. Anything else before I get a date?
Thank you, Your Honor. Nothing by the people further.
So for the date, Your Honor, in that, we would have to be able to arrange the in-person classes.
Sound like the whole family needs some classes, but I can't make the other people go to class. Does Mr. Tripp work?
Not at this time, Your Honor.
Oh, well, then he could go to the classes. But I don't know where the in-person classes are. You know, I'd be thinking Mr. Rice can do anything. I feel like he has all the classes, but those may not be free, so I do understand that. I'm not opposed to it. Maybe you need to get a referral from probation.
Okay.
But, yeah. And I am live streaming right now. So if you want to go back and play this for her, you can go back and play this for her. If you don't have if somebody don't have they don't want to say it with as much fervor as I'm saying it, the video is going to be there. You just show her this is what the judge said. And I mean it from the complete bottom of my heart. I mean it. I mean it. I mean it because I feel like she's trying to bully the system and trying to whatever. And I'm not going to have it. I'm not going to have it. Okay. So let's do this. And I want at least 6 classes. in order for me to accept the pretrial resolution. What I'm saying is, Trip, you can't listen to her, talk to her, and listen to me at the same time.
I just explained to her, I have seizures and right now I feel like I'm having a panic right now. I have medical issues for it.
Now, you're not gonna make me put you in the Wayne County Jail and mark your file medical.
No,
Okay, well, take a deep breath. We're gonna take a deep breath. If you need some water, they can give you some water. But let me say this to you, and you can take a deep breath. And if you need some water, they can give you some water, because court is stressful. And if the stress is gonna trigger whatever you're having, then we're gonna need to get you some medical attention. All right. I'm gonna set it for at least 6 weeks, 8 weeks out, because I want 6 classes in order for me to entertain the pretrial resolution.
Okay.
So I could put it October 29th, but I won't. I will put it. Oh, I can't put it. Oh, I could put it. I think I could put it. Let me see what time I'm on. Might leave. I could put it November let me see. That might not work. That's 12/25. That means I could put it November the 3rd.
Thank you.
Yeah, I'll put it November the 3rd. For final pretrial conference.
thank you.
And then I'm going to go ahead and put it on my trial docket as well, November 3rd. And so then I'm going to put it on the trial docket for December 2nd. So let's put November 3rd at 9:10. And then I'm going to put it for a jury trial. December 2nd. And know that it is first in priority. That's why I put it on the 2nd, to make sure. And that's at 9:30. So if the matter doesn't resolve, oh, I keep looking, this is Trip. And this is MFD. And that, all right. And then I want to have to lock nobody up while they wait in order to get the witness for the trial.
Do that. You gotta do that.
Anything further on behalf of the people?
No, Your Honor, thank you.
On behalf of the defense?
No, thank you, Your Honor.
All right, we're all set then. Everyone have a great day. Stay safe.
Thank you very much, Your Honor.
You're welcome.
Talk to Madam Prosecutor on this case, Judge, and I'm approaching on 2 things. 1, bond reinstatement, and PC on this case, Judge. She and I have already discussed it on this case, and we just both want you to hear the PC if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge. Right.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide.
Traveler. Okay.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Okay. Tell me what
So we looked at, well, I'm sorry, Madam Prosecutor, the interference with duties of public servant, Your Honor. Even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However, in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
They're
see
just
it.
trying to get him out of the car.
I don't
And
disagree.
It's classic sovereign case where got the license plate, think that what is the traveling by right is what I think how they term it.
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
But he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos, and go on YouTube, right? There are hundreds of videos where officers will literally destroy your car to get you out. When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Daly?
We don't disagree, Your Honor.
Right. You know what I mean? That's real life.
We don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know, did you hear that on the video? Right. And so in reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor. In this situation, it wasn't as if he was intentionally
Remember,
not.
this is just a mere probable cause.
Yes,
So,
Your Honor, I agree.
they ask you to come out of the car one time. Yeah, it's really, so, I think that there's enough probable cause to go forward now. The problem is, Mr. Daly, is that we revoke your bond. Your bond is set at 2501, and you've continually failed to appear. So, the case and the way that you've treated us, it shows me that you just refuse to accept authority. How are we supposed to deal with that? How do we deal with that, Timberl?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration, we have a Black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system. And from what I can see and what I hear out here from a lot of my Black male, and I'm sure it's common knowledge, is that because they are unfamiliar with the court system, they don't know, number one. Number two, when they do come in contact with police, and my mother is assistant chief of police, so I can understand, even when I was younger, I was taught that there are certain things that you have to do with when a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a police officer as a parent, or who isn't familiar and is being raised in this particular climate and seeing what they see on TV and seeing what they hear and everything that has occurred, you don't know what the proper steps are. I was trained from when I was grown up, what you do. I'm not saying that what he did was right or wrong. I'm not saying that how he reacted to this particular court, it is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration, number one, from his perspective, all defendants, can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now on the case. What you know about me, I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I'm not going to do this again, though. I promise you. I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? When you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, Do you have a Texas driver's license?
No, right now.
You're not allowed to drive.
Right.
You have a bond condition and you've signed an affidavit with me today promising you're not going to drive. I don't care how you term it. Driving, traveling, however you're going to word it, whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road unless you have approval from us. Do you understand? I don't care that you have to work. I don't care if you have to go to church. I don't care if you're going to a funeral. I don't care if you're going to wherever it may be. Do not drive. Do you understand? Heed this warning. You're not going to get another one. Okay, Timberlake, I'll reinstate the bond.
Thank you, Your Honor.
And
I'll talk to her. We were going to try to talk to Chief, but it's pretty busy
I mean,
today.
I think the case is only 3 months old,
Yes,
so
sir.
you've got time. You can do whatever you want.
Yes, sir. Thank you, Judge.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court now, but you must stay in touch with her and she'll tell you when you got to come back to court. If she comes back and tells me she can't get a hold of you because you're playing games or you've gone AWOL or whatnot, or you get arrested for something else, all bets off. We good? I'm not asking for much, man. You know, really. And for future reference, when you get into a pissing match with someone with the power of arrest, you are nearly always going to lose. It's just the way it works. And as a young Black man in today's society, you got to be extra special careful because things can go really wrong really quick. And there's evidence of that over and over and over. Okay? All right. Good luck, guys.
Thank you, Your Honor.
Yes, ma'am.
Thank you, Judge.
Thank you.
I'm not threatening you. Say one more word and that's 30 days. 30 days.